I'm Brian Brown, one of the founding partners at Brown Barron.
And I'm Leah Barron, the other founding partner at Brown Barron. We are a law firm that specializes in nursing home negligence as well as medical malpractice and birth injury. And today we're going to talk to you about what to expect once your lawsuit has been filed in court.
So, that's right, what happens next? After some procedural steps, your case is in circuit court in Maryland. And the right circuit court is where the defendant lives or where the event happened, where you got hurt because a doctor or a hospital or a nursing home was negligent in your care. So what happens next? The case is in circuit court, it's filed, the other side has their lawyers. What happens? Well, there's a process called discovery. And discovery is the most important part of the case. And why is that? Because unlike TV shows where there's a surprise witness or everybody gasps with surprise at something that happens, that's not real life. In real life, if the lawyers on both sides are doing their job, both sides know exactly what the other side has in terms of evidence and what everybody is going to say. Well, how does that happen? That happens through a process called discovery. That's where we build our case. We let the other side know our side of the story and build the best case possible. And we find out what the other side is going to say when trying to defend this case. You are the most involved at this point in the case. You can make it or break it just by how you participate in the discovery process. Now, there's lots of different kinds of discovery, but the main kinds that you all are involved in are interrogatories and depositions. So what are interrogatories? Interrogatories are written questions that we get from the other side, and of course we send our written questions to the other side who's defending the case. And they ask you all kinds of questions. Some are basic. What's your name, your address, what do you do for a living? And then they get into more details. Basically, why do you say we did something wrong? What happened? And what are the damages that you say happened because we did something wrong? And we'll have you into the office. Sometimes we can do it on the phone, but remember, these questions are under oath. So we have to be very careful and, of course, very truthful. The main thing is to give everything we have to make the best case possible. Because if we lay it out there, it could go a long way to working the case out without having to go through the rigors of a trial. Now, the other kind of discovery that you're most involved in is called a deposition. And a deposition is kind of like interrogatories because it's a lot of questions under oath. The difference is, instead of being written questions, the other side's lawyer gets to sit in front of you with a court reporter who takes down everything that is said by everyone. You raise your hand and you're under oath, and you answer questions from the other side. Usually the deposition happens after we've given them the written questions to the interrogatories and after we've given them the documents that we have. They take all that stuff, they put it together, they consult with their experts and their staff people to find out the best questions they can ask of you. And of course, we'll prepare you for the deposition, tell you all about how to answer questions, how to dress, all that stuff we go through for you. We're there working for you. But remember, it's very important. This is the most important part of the case, interrogatories and depositions. Now, of course, we're taking depositions of the other side. We're taking depositions of the doctors and healthcare providers that we think were negligent in your care. And we also take depositions of the experts on the other side who say that their defendants acted in a reasonable manner and didn't cause your harm. Just remember that all this process takes us to the next step to enable us to enter into discussions about settlement and decide whether or not we think we need to go to trial.
Great. So you might be asking, how long does all of this take? Well, it can vary a lot depending on what circuit court you're in, but typically it's around a year and a half from the time we file the lawsuit until we get through this entire discovery process that Brian has just described. And again, he laid this out, but your role in all of this is really limited. It's important, but it's really limited to helping us answer the interrogatories and then most likely to providing deposition testimony. And that would typically happen just over one day, the deposition testimony and maybe an additional meeting or phone call to help us answer interrogatories. All the other work that he explained, all of the depositions of experts, all of the expert reports, all of us taking the depositions of the defendants, and all of that work is done by us behind the scenes. What you do is help us answer interrogatories, help us get that information, and also to provide your deposition testimony. So really 2 events in the whole process that you're involved in, and the whole thing altogether typically lasts a year and a half if it goes all the way until the end. So if you'd like to learn more, please visit our website at any time or call our office, or you can subscribe to this YouTube channel. Thank you for watching this video.